Please, you permit me to stand on the existing protocols. As they rightly observed, I came quite late, so I wouldn't want to breach protocols by trying to follow any particular order. It's a privilege, actually, to be here for this kind of event, because I think it's a watershed in the history of the legal profession that we can have high-tech sessions like this. Years back, there was a kind of cyber phobia that many lawyers, they refused to break out from the traditional background of practice. But thank God for COVID. I think COVID marked a turning point for all professions. And that's why we are having this type of robust discussions that cuts across technology. The subject that we are dealing with in this session, from what I was informed, is law practice in the digital age, balancing professional responsibility and technological innovation. I'm happy about the prelude or the preview of ChatGPT. I think it has adequately set the pace for our discussions. And we have a very erudite panel of discussants. I had the privilege, I think sometime last week, to have a Zoom meeting with all the members of the panel, and I discovered quite excitingly and interestingly that all of them are masters in this subject. I think the only problem we may have today is with time, because the discussions will be time-bound. Each of them will be speaking for not more than 10 minutes. But I just want to say, by way of a preview, that it promises to be quite exciting. From what I'm even hearing before this our session, it appears the subject of information technology, ICT, and artificial intelligence has featured in the course of this workshop, and I think it's going to be now trashed. I won't say exhaustively, but we'll try our best to make an inroad so that we'll give everybody enough food for thought that when we leave here, we'll be able to advance the discussions. Maybe even we can continue the discussions on online panels, because this type of discussions never ends with just one workshop like this. It will continue, and I think lawyers now know that the internet is open for all of us to continue discussions, and so we'll continue the discussions online after this time. There are 5 aspects we are going to be looking at, because there are 5 panelists to discuss. Each of them will be taking a particular aspect, because I don't want us to repeat ourselves. I will be starting with my Lord, Honorable Justice O.O. Oyewumi, and she will be speaking and discussing on technology as a tool for effective administration of justice. My Lord, we want you to give us your own perspective. My Lord is from the National Industrial Court, and from our own findings, that court appears to be on the front line of leveraging on information technology. I think we are all behind them. All the courts are behind the National Industrial Court. That's why she's here, so that she'll give us a perspective of what they are doing there, and that will also assist us. She'll be looking at it from the perspective of adjudication in courts. So, my Lord, over to you.
Very well. Thank you very much, my Lord, the chairperson of this session. I also want to stand on all the existing protocols. I want to appreciate the organizers of this program, this section on legal practice. This is the second time that I will be opportuned to be a panelist in any of the programs that the section on legal practice that had cause to do. I also want to say that legal practice has moved from the conservative way we used to know it. And I want to encourage the bar to move with the tide and flow with it. The virtual trial that NICN has had cause to do every day. In fact, before coming here, I traveled to Lokoja virtually. I delivered the judgment, and that's what I've been doing. In fact, I had more than 100 cases in Lokoja. I'm a judge of the Abuja division of the court. But by virtue of us moving away from the conservative way, I've been able to deliver more than 60 judgments virtually. I've had cause to conduct trials every day. In fact, I had to stand down about 3 trials. I have to stand down about 3 trials for me to be here this morning. I had to plead with them to allow me to be part of this session, and then I'll go back. What is the essence of having virtual trial? But before then, I just want to take us through the background that NICN had, and that is what I will call the NICN 2017 Civil Procedural Rules, a visionary. Why do I refer to it as a visionary? Because this rule had envisioned the courts in this jurisdiction to live with the tide of courts all over the world and in other climes, and to ensure that whatever we do it in line with international best practice. We have in the Civil Procedural Rules, Order 6A, and that Order 6A introduced electronic filing system. We have Order 7. Order 7 introduced into the Act, into the rules, filing of cases and issuance of hearing notices through email and through SMS, WhatsApp messages. And immediately an email hearing notice is forwarded to a litigant or to his lawyer, there is a proof of service generated immediately. So you have the proof of service. So the lawyer won't come to court to be saying that, oh, I didn't receive the hearing notice. We also have our Order 38 through 33. This is what we call argument on record procedure. And all this, what they do is to ensure that we have quick and speedy access to justice, efficiency, and transparency. We also have what we call, in our rules, Order 45. Order 45 gives the opportunity for counsel. If you can't come after filing your final written address, you can just write a simple letter to ask the court to adopt it. Or you can even adopt it by that letter. And this was a kind of imported into our practice direction. So when COVID came, it became so easy for the court to quickly transit into virtual trial. So we now came up with the Practice Direction 2020. And the Practice Direction 2020 empowered the court to sit virtually. So you can sit even in the comfort of your house and conduct a trial. As counsel, you can sit in the comfort of your offices or chambers and file in your processes as well as conduct trials. And during that process, we were able to do a whole lot. National Industrial Court never go to sleep. We've always been there. And I also want to talk about the fact that in our virtual trials, it has not taken away the shine of being a legal practitioner. It has not taken away the due diligence that a legal practitioner has to put into practice. It has not taken away the tradition of having to put on your wig and gown and appear before a court and courtesy the court. The respect, the honor, and all that it requires for you to be a lawyer, and also the Judas is being observed during the virtual trial. We have what we call our mobile app. I was discussing with one of the executives of NBA He said he never knew that we have a mobile app. I said, we have a mobile app. In fact, if you go there now, please, can you project that? If you click on it, nicn.gov.adr, you will see court sessions right now. That's a proof of service that is being generated. Immediately you are served with a hearing notice. Please move to the next slide. These are the importance of what we have to do in our trial virtually. Then the next slide. I want you to wait here. Please click on Watch Live. This is a sample of virtual trial. While seated there, I clicked on this, and the learned counsel could actually see my sitting this morning. That is the beauty of quick, effective, efficient dispensation of justice. Justice without borders. Justice without any hindrance. Justice without any hitch. And I want to encourage the bar to flow along with the NIC as we take you through the ride of technical justice, not technical justice in the sense we know it, but deploying technology in ensuring that justice is meted out to everyone. Whether you are in the US, I've conducted a trial where one of the parties is in the US, and we did it virtually. He was able to tender documents and all that. You'll be wondering how I did it. Possibly during the question and answer time, I'll be able to give more details into that. But like I said, I want the NBA to flow along with us and cooperate with NICN as we are ensuring that justice is done to everyone without borders. Thank you very much.
Thank you very much, my Lord. Some of us, we have to download the app immediately we leave here. I particularly will do that so that we can follow up and we will also take the benefit of what people are doing. Maybe we'll be able to suggest such things in our jurisdictions. We want us to move straight away to the subject of AI, artificial intelligence. I think that one now seems to be posing a threat, because when we see something like ChatGPT that seems to be taking the role of lawyers headlong, then we as lawyers, I think we should sufficiently position ourselves before we are swept off our feet. I want to say something about artificial intelligence just by way of advice. From my own research, the leading exponent on the subject of artificial intelligence is a man called Professor Richard Ruskin. I don't know whether anybody has heard about him. He's the leading exponent of artificial intelligence in the whole world. As a matter of fact, he has a doctorate in the subject of artificial intelligence. He's a lawyer. I stumbled on him on a platform called LinkedIn. And ever since I connected with him on LinkedIn, I had to buy some of his books. He has such books like The Future of Professions. And he made us to understand that artificial intelligence is not only posing a threat to the legal profession, but to all professions. And so I would want to recommend that you do a Google search on Richard Ruskin, connect with him on LinkedIn. Sometimes on LinkedIn he holds a lot of lectures, and the lectures are quite illuminating. He is the one that allayed my fears and made me to understand that artificial intelligence can never take the place of any profession, not even the legal profession. To speak on the subject of artificial intelligence, we have Inemesit Dike. And from my interactions with her last week, I think she's very, very vast. She has a mastery of the subject. And so I would like her to discuss particularly this aspect of the threat. Some of us are afraid, but it's going to be a benefit. And so I would like her to highlight the benefits of artificial intelligence to the entire profession, both the bar and the bench, and perhaps will also further allay our fears that we'll not be afraid that artificial intelligence may make us irrelevant. So I think she can take on that discussion straight away.
Thank you very much, my Lord. First of all, I would like to stand on existing protocol and want to also say it's a privilege I do not take for granted to be able to sit on this panel with the erudite speakers on this panel and to be invited by the NBA SLP to speak on such a topic that I love so much. I'll just give you a little bit of background and delve into the concept of AI. So I'm privileged to serve as the chairperson of the Digital MBA, and I thank President Michael for that opportunity. I would like also to say thank you to the President Emeritus, Mr. Olumide Akpata, who is here, who I believe was one of the first people that believed that AI, law, and tech had a confluence where lawyers needed to be dragged, willingly or not, to the shores of tech. So thank you very much to the current president, and thank you very much to the President Emeritus. Tech is now a buzzword. AI is now a buzzword. It's creating a lot of fear, especially in the older generation. But what I always like to say is that AI is zeros and ones. That's what binary is, just zeros and ones. And there are people like you and I who are sitting on the other side of the computer inserting this documentation into the data sets. The previous speaker who was speaking on ChatGPT referred to data sets. One of the things that I know that lawyers, we often like to focus on are just our own industry, but the world has become bigger than that. The lawyers that are going to continue to prosper are the ones who are functioning at the confluence of law and any other industry. And the only way to do that is to use technology. So if you think of artificial intelligence as zeros and ones that are channeled into the certain data set to automate the human mind and automate human intelligence. But guess what? When we say, oh, we don't think AI can take our jobs, AI is more than one person's brain. It's the sum culmination of as many people's brains as possible. And we're going to use some tools here, for example. So when you use ChatGPT and you insert information or request into ChatGPT, it's going to give you the search, the result from the search that he has generated from all the data across the world. No human being can compete with that. No single individual human being can compete with that. And I hear that we say, oh, AI is not going to take our jobs. We don't need to be afraid. We need to be very cautious. I always like to sound a word of notice that AI has the ability to make legal services redundant in certain areas. It also has the ability to make some lawyers lose their jobs. The question is not, will we lose our jobs? The question is, how do I future-proof myself to ensure that I'm not one of the victims? And the question goes this way. If all of us are sitting on this panel and the future is coming, the future is already here. What do I know that he doesn't? How can I ensure that irrespective of the kind of products that comes out tomorrow, because today is ChatGPT, tomorrow is something more fantastic. How can I ensure that I'm always going to beat any artificial intelligence that comes out? That takes me to the subject of technological competency. In New York, in the UK, it is paramount that there's a duty of technological competency that every lawyer owes his clients. I would like to see by a show of hands, please. How many of us in this room call ourselves tech lawyers? How many of us will say that we are tech lawyers? Okay, we have a few hands. How many of those hands that have been raised up have certification to prove that? Just one person over there. Up? I don't see that. Okay, 2 people at the back. That's 3 people in this entire room. Let me give you some statistics. Q1 2022, we had, in the venture capitalist space, we had, depending on who you ask, $4.5 billion to $6.5 billion that was invested into the venture capitalist space in Africa. Nigeria is at the forefront of that. Now, everywhere there's money, there's business. Everywhere there's business, legal services have to flow. How ready are we to ensure that where this business is going, we understand our clients enough and we have the certification to prove it? Because whether you understand the AI or not, it's coming. It has come. If your client, you're sitting down in a room with a client and your client is negotiating and you know that that client, you don't even know that the client is not investment ready, you are actually at fault. Because every client is depending on the lawyer for the lawyer to have the technological competency in AI and in any tool that comes out in order for you to be able to represent the client in a proper way. Now, look at the examples that we talked about earlier in ChatGPT. Imagine a lawyer going to court and presenting fake cases. We're not going to sue ChatGPT, even though OpenAI, which is the source owner of ChatGPT, has been sued. You can Google it up. There are case laws. There's a case right now in court against OpenAI, where some writers and authors have insisted that OpenAI has used their books to train this ChatGPT without giving copyright and without giving compensation. Now, which kind of lawyers would they need in order to properly represent them in court? There's a huge labor arbitrage from the West to India. Why? Because it is assumed that in India there's a large ecosystem of tech lawyers. And this can be proven by their certification, either by their masters or by their certifications in artificial intelligence experts, and these things are available. But there is such a dearth amongst the lawyers. We believe that we need to just focus on the practice of law traditionally. But that has to change. There was a conversation I was having with a client, and in the room, we talked about, the person's investment readiness and things like that. At the end of the conversation, the opposing client on the other side came to me and said, I'm not quite sure that my lawyer understands these terms. As simple as the terminology. So for example, if I ask you what is an API, how do you negotiate if you have a client that comes to you and says, look, I've built a third party, I've built a platform, but I would like to be able to sell my APIs. Would you assume that that person is asking to sell his product or he wants to sell the APIs? These are the issues, because your client at the end of the day is becoming more and more knowledgeable about what to be done. So in my own opinion, I do believe that artificial intelligence has the capacity to take over a lot of jobs. And this is not just my opinion. In June, at the Yale CEO Summit, the 4 big techs in America actually lobbied that there should be more regulation in artificial intelligence. Right now, as we speak, we have something that is underway called the European Union Artificial Intelligence Act. Remember, the European Union is the one that gave us the GDPR. And then Nigeria followed and decided to implement the NDPR. And now it's an act. Now there's something called AI Act. And AI Act has categorized artificial intelligence into 4 different categories. Please note that this is still a draft, so there may be changes. But really, we have started looking at things like what kind of AI is destructive, what kind of AI affects fundamental human rights, what kind of AI is useful but will be destructive to cause possibly the human extinction within the next 5 to 10 years. So it's legit. There's a reason for us to be concerned, but the reason for us to be concerned is even more because if you think that education is expensive, ignorance is even a bit more expensive. So there's a high possibility that in the next 5 to 10 years, the human existence as we know it may be extinct. And if the human existence is extinct, then how about the legal services industry? We can't continue to pretend and act like ostriches, burying our head in the sand, thinking that things will just go over our head and everything will at the end of the day be okay. I would like to urge, and especially as the digital MBA chairperson, that we build an ecosystem of lawyers who don't just hear the buzzwords, AI, tech. At the end of this session, you should ask questions and find out where you can get certified. Do you want to be a lawyer and also a product manager? Do you want to be a lawyer as well as the data analyst? Can you solve the problems that are found within the legal services industry using technology? And I'll give you a very live example. I really love what Milord was speaking about what the National Industrial Court is doing. As a chairperson of the Digital Committee, at Digital Committee level, we've been talking about how to make interaction between the courts and the lawyers a lot easier. So for example, in the need that you need to not sit in a particular day, but people have expected you to be present, can we use technology to ensure that there's seamless communication within a specific time and also seamless communication in giving another date? So we have a reduced experience of lawyers traveling from far and wide, coming into a particular institute and finding out that the court isn't sitting. Technology can solve that. But the question is, why are we waiting for outsiders to use technology to solve our problem? We are the ones that have this experience. We need to step up our knowledge game, make sure that we can also function at that place. For example, myself, I'm a lawyer, but I'm also a product manager certified. I'm also an artificial intelligence expert certified. I'm also learning to be a software engineer. With that kind of experience, I don't need an outsider to come in and solve my problem. I can sit here and say, look, I'm going to build something that is going to make it easy for me, Lord, to just send a message, and it goes across the registrar, goes across all the parties. This is the reason why the court will not be sitting. This is the time that we will probably be sitting. Please choose a convenient date. I believe that AI is meant to make our lives easier. AI's implementation can only be done if we decide to move away from everything, things that have not even been taught to us in law school, and focus on how we can sit in this room and create solutions to the problems we are talking about. And there's money in these solutions. I need to talk about that because most times, I know I'm known for my sneakers. Everywhere I go, people always see me and identify me as the sneakers lawyer. But I do it intentionally to let people know that apart from using the traditional practice of law, there's also money to be made from the comfort of your home. I know Milord was referring to LinkedIn. I've gotten a lot of referrals from LinkedIn. Because somebody sees that says, this lawyer understands the terminology I'm going to be speaking about. If we are talking about an issue that happened on a technological tool, for example, Jira or Slack, who uses Slack in the room? Please, we use Slack in the room. Who uses Fireflies.ai in the room? Okay, who uses Jira? Let me just break it down a bit. So Fireflies.ai is an automated system that helps you to take records of meetings. So for example, I'm talking now like this. You just put your Fireflies.ai up. It just automatically gives you a record of everything I've said. That time of you going back and forth and trying to remember what was said in the meetings is over and done. Slack is a tool that is you can use it as a mobile app, you can use it as a web app. All you need to do is download it on your phone, and you're able to have things that we call huddles. Huddles are really just like video calls or audio calls where you can interact with other people quick and instantly. Jira gives you a full overview of what everybody is doing at the same time. Let me give an example of my practice. We are fully remote. What we do is once a week, we come together to do what we call huddles, and then every day we have something we call a sprint meeting, right? These things should no longer just be on the outside where other industries apart from law does it. It's something that should happen to us naturally. In my office, we don't have meetings where we are sitting down like this. You're standing, you're giving a discussion of where you were, what you need to do next, and everything is done remotely. And imagine a situation where an international client, and when we're talking international, well, let's not even go outside to the West. Let's focus on Africa. You know, with the African Continental Free Trade Agreement, Africa has become one large market, right? And this, with the seamlessness of businesses, the seamlessness of technology, African lawyers need to step our game up in order to be able to present ourselves in a way that we can be the first people for us to be able to, where labor arbitrage will come to us. I'm sorry, but my time is up. I need to respect me, Lord. But I would really love for us to have more questions on this matter because I'm very passionate about it. Thank you very much.
I think she deserves another round of applause. You can see the passion with which she discussed the subject. The passion is infectious. It's a learning curve for all of us. All of us here, I think we are going to take a lot of things home, and then we are going to upgrade our practice. And I think that's the essence of this type of workshop. She has said certain things. I thought she will completely allay our fears. I wouldn't want to say she heightened our fears, but I think she sounded a note of warning that if we are not careful, AI may actually pose a threat to our legal practice. But she made a very valid point that these tools are like servants, they are not masters. In other words, these are tools that we should use. Artificial intelligence, we can leverage on artificial intelligence and enhance our practice of the law. It's only very pathetic that apart from some very few lawyers, most of the artificial intelligence platforms are being run by people who are not lawyers. For instance, Law Pavilion, is he a lawyer? It's not a lawyer. No. You see, my Lord says he's a lawyer. You would think he's a lawyer, but he's not a lawyer. But he has been able to put something like that together. So we are throwing the challenge to lawyers. Chief Obi, Senior Advocate of Nigeria, will recollect that as far back as 2008, we set up a website, Nigerian Law Guru website. He's a consultant. I'm the editor there. We did that. That was our own contribution. It's only that I became a judge that same year, and then I couldn't follow up. But the site is still there. So it's a challenge we are throwing out to lawyers, that lawyers should be able to go into software architecture and engineering. I think it will be best if lawyers can put some of these things together and put it at the disposal of lawyers. I think it will be more suitable, and that will also allay our fears. In any case, we will leave the subject of artificial intelligence for now. We'll be coming back to some of these things during the question and answer sessions and during the times when we throw it open to comments. We'll give opportunity for that. But I want us to go straight to another important subject that has just cropped up and is cropping up very strongly, is the subject of privacy, data protection, and protection of what we call digital assets. I think it was the second bill that the current president signed, on Nigerian Data Protection Act. And we want some kind of discussions on the subject of data privacy, data protection, and all these type of things, so that we as lawyers, you see, we are getting to a stage in legal practice whereby everything now is getting to high tech. It's quite high tech. There's hardly any case now that you'll be seeing. There was something that happened recently. A lady claimed to have, a young girl said she was the highest scorer in JAMB. And she said she scored whether 362 or so. And then they gave her scholarship, they did certain things, and she wanted more scholarships. And then she came out to the space, open space, and started canvassing. Then JAMB came out cautiously and said that is not the highest scorer. That girl actually got 249. But what shocked me was that a lot of lawyers jumped into the space. And I saw lawyers berating JAMB, condemning JAMB. Even some of them said that they should ask for apologies. As somebody who knows technology, I listened very well when the JAMB man, when he spoke. And I saw clearly that he had his point. Because digital evidence is foolproof. It's not like I believe or I don't believe. And when he came out with his facts and said there was communication between the girl's phone and their servers, I said that's all. There's no way she can wriggle out of it. But I was surprised. Many lawyers were ranting and saying many things until it became very clear that the girl was at fault. So we should get into these things properly. We should be properly educated. Yeah, there was a paper I wrote about 15 years ago. It's titled Legal Research in the Digital Age. If you Google it, you will see it online. I mentioned it that time. I said the concept of literacy has been redefined. It's no longer the ability to read and write. What we now talk about is computer literacy. So if somebody is not computer literate, he's not an illiterate, even if he's a lawyer. So we'll look at this aspect of privacy, data protection, and protection of digital assets. Emmanuel Edet will be discussing this subject. Emmanuel Edet.
Thank you very much, my lord. I hope you can all hear me very clearly. Thank you very much. My name is Emmanuel. I work with the National Information Technology Development Agency, and I'm the head of the legal department in that agency. I've been around this circle for quite a long time, just a little bit more than 2 decades, and it's a privilege to be here. So I stand on all existing protocols. One of the things that fascinated me way back that led me into this particular section where technology intersects with law was a quote I read from Justice Caribe White, I think, JSC, in a judgment way back in 1989, where he said that the courts cannot be blind to the mysteries of the computer. And it was funny to me then. I asked myself, is computer really a mystery? And I think the answer is no. Computer is not really a mystery, and that's why we should embrace it. Today, we have read in several places where it says that data is the new oil. What does that mean? The global economy today now runs on data. Everything about the economy is data. Everyone seated here has been reduced, as Inemesid mentioned, into zeros and ones, in case you don't know. So if you have an ATM card and you cannot authenticate yourself, you cannot withdraw money from your bank, even though you have money in the bank. How do you authenticate yourself? Through data. And that's why there's a need for us to protect our own privacy. Section 37 of the Constitution expressly provides for the protection of privacy in communications at home, but those boundaries no longer exist. Because once you have a phone, whatever you do on your phone is recorded. When you speak, when you type, where you go, because by default, your Google Map is always on unless you turn it off. So once you buy a phone, first of all, it forces you to enter an email. Before you open an email or before you start using an email, it asks you some questions. How old are you? What's your date of birth? What are your full names? It automatically knows your country because of geolocation technology. And then eventually it will ask you some questions that is only peculiar to you. That is because they want to identify the unique you. And that is what is used for sale. Have you ever wondered why an operating system like Google operating system is free of charge? Why Gmail is free of charge? Why Yahoo email is free of charge? Because you are actually the market that is being sold. Your personal data is used to maintain those systems. And so if you don't provide them with your data, they cannot function. And that is why there is a need for data protection. What we've discovered over the years is that the function of technology and use of technology is a matter of convenience. People pick up devices and use them as long as they are convenient. And it doesn't matter what you say, no matter the caution. It's only when problems come that regulators will now be asked to step in to address those problems. And what is the greatest problem of using technology? It is trust. We need to trust what we are doing. You need to know that once you open your bank app and you send money to your wife or your brother, that money goes through. When the money doesn't go through, it becomes a problem. But as legal practitioners, what are we doing in that space? Inemesid mentioned the fact that a lot of investment has come into Nigeria in terms of startup companies, and Nigeria takes about 1/3 of investment that comes into the entire African continent. More than that, even more than that. We have about 5 unicorns and 7 in the making. A unicorn is a $1 billion valuation company. How many lawyers actually have the opportunity to advise these companies on international business transactions? These are issues that we need to consider as lawyers. So basically, your data is what identifies you in the digital space. And whether we like it or not, we leave footprints. Everywhere you browse, every search you make is automatically associated with you or the device that you used in making that search. And this leaves a footprint to help these technology companies actually identify what you want, identify what you're thinking, and then they send you targeted advice, targeted adverts. Sometimes when you open your email or when you search for something, as soon as you open your email, on the side you see the advert relating to what you have been searching for since morning. That's what they do with your personal data. And so the GDPR, which was basically from the EU, was designed to deal with technological companies that misuse your data. They actually get your data, sell it to other companies to advertise things to you, and that's why you get some of those unwanted messages that you get all the time. So, what can we as lawyers actually do in terms of legal practice when it comes to dealing with data protection and privacy issue? Number one, understand the subject matter. Even as a lawyer, you're going to be managing personal data. The recent law signed by the President, the Data Protection Act, categorically gives responsibility to data processors, which I believe most lawyers are data processors. Because whether you like it or not, you have the data of your clients. Very, very important. You hold the data of your client. So there are rules you need to follow in managing that data. Do you know those rules? Do you realize that all of a sudden tomorrow you can wake up and you're in violation of the law without even knowing it? But we are the ones that usually quote that ignorance of the law is no excuse. So it is no excuse. You need to learn and understand what privacy is about in the digital environment, and also understand what you can do in terms of the technology and commercial space. Basically, the Data Protection Act provides rules of management of data. When we say protection, we are not talking about preventing data from being used. Rather, we are talking about managing the use of data in a safe environment in order to protect the privacy of those who actually own this personal data. Of course, there are principles set out in the law for lawful use of data. You have to seek the consent of the person who has the data. You also have to be specific. You have to make sure that the data you collect is relevant. I cannot come to take, for example, I'm a lawyer and I need to handle your matter. I will now start asking you about how many wives you have if it's not relevant to the subject matter I'm handling. Also, there are certain rights that has now been allocated to data subjects. They have the rights for data portability. They have the rights for their data to be erased. So if you have a data of a client and you've concluded the matter, the client has a right to tell you, I don't want you to have my data anymore. Get rid of it from your system. Of course, you also have a responsibility to ensure that the personal data of your client is adequately protected in terms of security measures. So it's not just to get an antivirus. You have to develop a privacy policy and security measures within your own computer network systems in order to protect the data of your client. Also, the Data Protection Act specifically lists punishment for those who actually violate the provisions of the Act, and the Commission is there to enforce that judgment. This is just law. This is just a nutshell of what the data protection law talks about. But looking at the larger picture, when we talk about digital assets, how many of us actually have digital assets? Is there anybody with digital assets? That's strange. Lawyers don't have. My Lord has digital assets. But do you know that you actually have digital assets you're not aware of? Take, for example, your currency in the bank. What do you think that is? That's a digital asset. Research has shown that in terms of cryptocurrency, Nigeria is the second largest trader in cryptocurrency behind Thailand. How many lawyers are in that space? Very few. Now, the interesting thing about digital assets is that most digital assets that run on blockchain platform are decentralized. And that alone gives nightmare to regulators because you have currencies that you cannot control. We are simply going back to what we may call the trade by barter system. Once I have a storage of value, I exchange it with you for whatever value you have that I like, and then we go our way. And if you can exchange that value for another value, excellent. No central bank is involved. And that creates a problem for regulators because you need to actually monitor monetary policy. I know I have limited time. I could actually go on forever on these particular issues. But what my take is here is that as lawyers, we should understand that technology is not the future. Technology is here. I jokingly used to tell people that technology is designed to upstage existing laws. Well designed for that. I remember when I first came to Abuja in those early days, if you have a taxi and you don't paint it green and white, you'll be chased all over this town. But today, with Uber, who bothers whether your taxi is green and white or blue or purple? You call for the Uber and you jump in and you move. Same thing too with Airbnb. Before, when you need to have a hotel, you will go through the process of inspection. People will come and look at where your hotel is located and everything. But today, just sweep your room and put it on Airbnb. You have automatically become a hotel. That is what technology does. It ensures that there is transaction. It ensures that at every point in time, it's convenient for everybody. But there are issues that always come out because technology in itself is absolutely neutral. It is how we apply this technology that actually becomes an issue. And that it is at this point that I think lawyers ought to take a stand and be able to make, sorry, I don't mean this in a derogatory manner, make useful contributions to the development of technology. There are so many laws affecting technology, policies that are being churned out by the executive arm of government. Lawyers do not play their advocacy roles when these structures are being created. We need more active participation. I was privileged to be at the Session of Business Law Conference, I think about a couple of weeks ago. And one of the things I said is, I know we've been told that we are ministers in the temple of justice. But believe me, that temple is shrinking. We need to leave that temple and go out and be advocates in the streets to ensure we have a safe environment where technology can be applied. Thank you very much.
Thank you, Emmanuel Edet, Esquire. We have a lot of food for thought coming from that discussion. What struck me very forcefully was that lawyers should be conscious of their responsibilities, particularly in relation to the data from clients. Privacy. I think it's Section 37 of the Constitution that guarantees the right to privacy. In my jurisdiction in those states, we told lawyers to be submitting CD-ROMs, soft copies of their court processes. And what has shocked me, even yesterday night, I was looking at the soft copy sent by a lawyer, and I saw processes relating to the case, and then I saw some private documents of the client. If everything, they put everything in the CD and sent it and filed it in the courts. I've even seen a video. Somebody put a private video in a court process that is they filed. You see, we should not wait until trouble comes, because by the time you take private information about your clients and put it out in the open space and there are problems, then that law, the act, I think there are some punitive sections. I went through it and I saw that there are offenses. We are now processors of data, but if we don't manage the data properly, then we'll be committing some offenses. So this type of thing now should make us to be aware. We should have a sense of responsibility when we are dealing with data. And my prayer is that we'll be able to take something away from this discussion. We'll go to another subject which is also connected, the use of technology to enhance compliance with rules of professional conduct. We'll be looking at it now, technology, professional conduct. How will technology enhance compliance with the rules of professional conduct? It's a very narrow area, but a very, very delicate and salient aspect. And Idris Mohammed Esquire will be telling us something about this area.
I think it's still morning, so good morning, everyone. My name is Idris Mohammed, as introduced. I'm a practicing lawyer in Kaduna. I have about 2 decades of practice. Okay. I have about 2 decades of practice under my belt. Most of it has been in the technology space. So I would be talking basically on the intersection of the law, particularly as it relates with our rules of professional conduct. I'll also be touching base on those aspects of technology law that we could take advantage of. When I'm saying this, I'm looking, Inemiset and Emmanuel have already touched based on some of these aspects, but I'll be giving further details on this. As it relates to the rule of professional conduct, these are the rules that have been enacted and put into place to guide the way we practice our law. I think Emmanuel mentioned some, but mentioned particularly as it relates to data processing. That is one of the rules that we must comply with. But in respect of this, okay, I failed to mention that I'm also the alternate chair for the digital committee, which Inemiset gladly chairs on our behalf. As part of our work, we're looking at how we can enhance practice and make things a lot easier. One of the things that the rules of professional conduct says we must have is to, Rule 10 thereof says that we must have a stamp and seal. And thanks to the work of former presidents of the NBA, that stamp and seal has come into being. But I must say, have been the secretary of a branch, the process of which we get our stamp and seal is very cumbersome, and logistically it is even a nightmare. And part of the work from my president, Pata's previous administration that has flowed down to this particular administration, and which is one of the top priorities of what the digital NBA committee is going to do, is to look at ways of digitizing our stamp and seal. Our bar practicing fees are paid online. Our registration for conferences like this are paid online. So it's a low-hanging fruit for us to complete that process and make digital stamp and seal possible. It is work in progress, and I'm sure before the end of this tenure, we should be able to do it. The next issue is also as relates to our annual practicing license. The rule of professional conduct also states that every year, before you can practice in court, you must earn some form of continued professional development points. And as a result of these continued professional development points and the payments of your bar practicing fees, then you are entitled to an annual practicing license. The ICLE, Institute of Continual Legal Education, properly established and under the leadership of Mr. Tubena Erujekwe, has been doing a lot of work in these aspects. And if we tie up all of these together and use technology, the annual practicing license can easily be given to each and every one of us in compliance with the RPC. Then there's a very topical issue, which to some extent, even during the bite-sized series, the speaker touched on it, and that has to do with the issue of advertisements. Is there a line that is being crossed by most major law firms have websites? Is there a line that is being crossed by not compliance Rule 39? Advertisements are allowed, as we all know, but there are certain rules which we must comply with, specifically that it should not supposed to be in comparison with other law firms. You're not supposed to come out and say, I am the best so and so. So in making out all of these our websites and our presence online, either in the social media or with our web presence, we should ensure that we comply with these rules of professional conduct. Very importantly, I'm sure the previous two speakers have spoken about it, but whenever I have an opportunity, I always like to talk about the opportunities that are available for lawyers in this space. Now, I practice a lot within the communications subsector, and one of the things I've noticed is that there's a dearth of expertise, particularly here. What a lot of the companies that are within this space do is that they just wing it. So what do I mean by this? They employ a lawyer that learns on the job. It's happening every day. I have a friend that's just recently been employed as a company secretary of a major law firm that has no experience whatsoever in the telecommunications space. And what is she doing? She's reaching out to people like us and talking about it. On the NCC website, for instance, in their individual license category, all of these things are online. There are over 1,000 licensees covering different aspects of communications law. 1,000 plus. Recently, the NCC has just given 29 licenses to mobile virtual network operators. What are these people going to do? They're going to provide similar services like what you have with your MTN, which are the major network operators, but they will be piggybacking on the existing network and the existing infrastructure. For all of these licensees, they need some form of legal advice, some form of legal backing and legal advisory on issues of regulation, on issues of compliance. The NCC regularly brings out regulations, determinations, and directives, which are always on their websites. And if you're not within that space, you cannot advise on this. So alone, I can give it to you for free, that if you get knowledge and certification on these places, you would be in hot demand. It's a no-brainer because there's a huge depth, lack of depth in these particular areas, and they are every day looking for new practitioners to come into the space. As a parting shot, I would advise, especially the younger ones, I think that point has been made right from the BITE series to the two previous speakers, that we cannot run away from technology. It has come here to stay with us, and we need to embrace it and embrace it quickly. So thank you very much for giving me your attention.
Thank you, Idris Mohammed Esquire. He talked about the issue of advertising. I think we'll still revisit that issue. I don't know, I've left practice now for more than 15 years. When I was in practice, I think there was a clear prohibition against advertising. But I wouldn't now know whether the rules of professional conduct has now allowed advertising. But what we see some lawyers do on social media, I think it's getting out of hand. I mean, lawyers now coming all out on social media, soliciting for clients and parading all kinds of qualifications and all types of abilities on social media. I think we'll still come back to that aspect, because when we talk about professional misconduct, I don't know whether many lawyers are not already going into professional misconduct on social media under the guise of some form of advertisements. So we may still come back to that. But we'll take the last panelist now. He will be speaking on a very important subject that has cut across everything we have been saying here today. It's the subject of cyber security. It becomes very paramount because almost every activity is now carried out on cyberspace. It was Professor Richard Susskind who said something very profound in one of his books about the courts. He said the court is no longer a place, that it's a service. That's why you now have online courts. That's why my Lord can say she can be here in Abuja, and then we'll be doing a case about somebody in Lokoja, somebody in the US. And the courts across all professions. Take banking, for instance. I'm sure some of you have not entered any banking hall for some months now, but you are doing your banking. Even medicine now, telemedicine, there are many aspects. So how safe can we be? Even if you come to the aspect of banking, I don't even know what is happening in that sector now. We have traditional banks, but there are many agencies, I don't know what to call them, OPay, and many platforms where you carry out banking transactions. The question we should be asking ourselves as legal practitioners, how safe is cyberspace? So, one of the last member of the panel, Mene Ajakovi, I listened to him last week. It looks like he's on top of the situation. He will be telling us certain things about cyber security with particular reference to legal practice. So he will tell us some things now.
Thank you, my Lord. Can you hear me? I prefer this. I prefer this. Thank you, my Lord. I will start with Lokoja. I sit on the board of a mining company. And operates out of Lokoja. We're sued 2 years ago. And from the inception of that matter till the end, I never showed up in Lokoja. The matter was completed and judgment was delivered last Friday by Honorable Justice Oyewumi. So it's a confirmation of everything she just said. Then secondly, no matter how you discuss cyberspace, you must come down to cybersecurity because it's the foundation on which everything stands. So talk about AI, talk about your data protection, talk about anything. At the end of the day, if you don't have a secured cyberspace, it's like building a fantastic home, 5-bedroom duplex house somewhere, and you don't have a gate, you don't have windows, everything will be open to violation. So cyberspace cybersecurity is very, very important.
So I started practice 28 years ago. And at that time, I met practice using typewriters. People were using typewriters, and we used to store our data in files and in file cabinets. The ultimate storage system at that time was the file cabinet or safe. And that was how we met it at that time. If you left your office, you have to go back to your office and collect any document you forgot. You can't download it from the cloud. You can't call it up from your email. You have to go back to the physical place where your documents are stored. You see, as lawyers, the most important ingredient for our practice are not your books, it's the client's information. You receive client's information confidentially, and you transmit it, you translate it into pleadings, you translate it to wills, you translate it to memorandum of understanding, you translate it to all sorts of documents. But the tools, the ingredient of your trade is client's information. And how do you store it? In the past, as I alluded to, those information were stored in files, but now they are stored in emails. Those information were stored in safe, now they are stored on the internet. They're stored in cyberspace. Now you see, technology has foisted upon us a transition in the storage of data. Technology has foisted on us. So instead of storing in physical form, it is now stored in cyberspace. Because of that transitioning, the issues of cybersecurity now becomes very important. I'm going to read. So what is cybersecurity? Cybersecurity refers to the practice of protecting your computer system and network data and digital information from unauthorized access, damage, theft, and disruption. It's about protecting your computer system. So the information that you've taken from clients, that you've processed into pleadings, that you've processed into an agreement, that you've processed into a will, is now stored in your computer system. Now, if that computer system is violated, you are at risk. So cybersecurity deals with the practice of protecting your computer system, your network, your data, your information, your digital access from unauthorized access, unauthorized violation. and it's always for the benefit of yourself and for your client. I have an example to give. I'm involved in a particular matter currently that speaks to the failure of cybersecurity. I was doing a transaction on behalf of a client with a marine company, a turnkey project, and it was time to make payments to a European supplier and service provider. The correspondence between the parties were violated. The correspondence were compromised, and at some point, the sum of $2 million was transferred to a fake account. The money is now in that account, and I've been called upon to intervene to how to retrieve that sum. Now, the problem is, if there was cybersecurity at its optimal level, there wouldn't have been a compromise of the email, there wouldn't have been a compromise of the financial details that led to the loss that we're talking about. So it speaks volume, and it tells of the importance of cyber security. Now, one aspect of cybersecurity, one aspect of violation of cybersecurity is phishing. Nigeria tops the third. Last year, Nigeria was third on the list of phishing attacks. Phishing is P-H-I-S-H-I-N-G, phishing. It's a system in cyberspace where you register or you create a dummy website, and you use that website or that information to be able to extract, mimic an original one to get vital information from any target for that attack. So Nigeria topped the list on that, and in 2020, it was discovered that the loss that came as a result of cyber crime was in the excess of $800 million, according to the report of Nigerian Communications Commission, NCC, that the loss occasioned from cyber crime was in excess of 800 million. That speaks volume to the importance of this. Now, speaking as lawyers, what are you supposed to do to be on the right side? We've seen that if you don't do anything, you'll be violated. They are very basic steps, because I'm speaking from the perspective of a practicing lawyer and not from a businessman or a software engineer. What are the basic things that you are supposed to do to ensure that you are not exposed? There are very basic things that you are supposed to do. First of all, encryption. Your communication, you must think in terms of encryption, end-to-end encryption. Your email communication must be encrypted such that what I described, the incident I described, does not happen, so that your communication is not compromised, your communication is not diverted, and your information that you receive confidentially from clients are not stolen. That is a responsibility. In addition to that, it is our responsibility as lawyers to create a very robust and almost inviolable cybersecurity ecosystem around our works, around our files, and around our documentation. We must also ensure that our document filing system are backed up. Because nowadays, since we've transited from the hard cabinet to cyberspace, there's a need to back up so that once you suffer a loss of one copy, you have a backup of the other one. These are very simple steps that we should take. Then in our communication with our client, we must also ensure that our communication, that the client is aware of the steps that you are taking. And the fact that you are also using is a document in line with the purpose for which you got them. It's not to get a client's client's information and trade those information. We treat those information with confidentiality, and we should treat them safely. Then another thing that we're supposed to do with regard to clients' information and in relating to clients' document is to also ensure that the integrity of documents is to ensure that they are protected or preserved in such a way that there are no addition. So the use of PDFs, for instance, the use of encrypted code, so that documents are not altered, documents are not changed or violated in any way. These are some of the steps practical steps that a lawyer should take in dealing with documents, and also ultimately in the fulfillment of the NIDPR, the one talked about by Mr. Edet. Because in document protection and document control, you must also do it within the bounds of NIDPR. That is very crucial. So in terms of cybersecurity, it's all about protecting documentation. It's all about handling documentation within, in a civil way, that they are not violated by cyber attacks. Now, in terms of privacy and consent, I failed to mention this. Lawyers should be mindful of privacy laws and regulations when collecting or sharing clients' data. So, obtaining consent from the client regarding the use and disclosure of their information is very crucial. So overall, the responsibility for cybersecurity in relation to our dealing with our client rests on the lawyer and not the client. We have ultimate responsibility for securing the data. We have ultimate responsibility for how we use the data, and we have ultimate responsibility on how the data is preserved. And it is for us to acquire the robust education, the information that is required to be able to dispense our responsibility in the ecosystem of clients and customers, clients and lawyers' relationship. That's what we should do. Thank you.
Thank you, Mena. I sounded a note of warning at the beginning that all the panelists are top-heavy, but I will have the challenge of time. The subject of cybersecurity can form the subject of an entire program. What we should do is that we use this as leverage to go and do some further research. And I hope that we got some points. At least it made us to understand the aspect of encryption, coding. When you go on Google on cybersecurity, you will see a host of approaches, and then you will leverage on those ones. I've just been told now that there is a book launch. I don't know whether they are fair to us. Bringing the book launch is like a novus actus interveniens, a new act intervening, but we have no choice. They've cut off the question and answer and the comment session. I've just been told that there will be no time for question and answers, and that if we have questions, you can put them in writing and submit to Bayo Omole Esquire. I hope you all know him. You submit it to him, and I will guarantee you, we'll send, just put your name, put your email address, put your phone number. I will guarantee you, the member of the panel that is to answer that question will answer the question and send it to your mailbox or to your WhatsApp or to your text. You will get a response from us. That's a firm promise we are making. We are sorry about that constraint of time, but we have to round up this session at this time. Thank you very much.
Thank you very much, my lords on the panel. It's been an honor. I want to apologize that we started a little late, but this has been an enriching session, and I'll crave everybody's indulgence to give them a round of applause again, please.
As I was saying, this is the flagship of the section on legal practice of the Nigerian Bar Association, the journal. And I was going to tell you why I say it's our flagship. Training and retraining of lawyers is one of the principal aims and objectives of the section on legal practice of the NBA. And the principal way we do it, because we can't be having conferences like this all the time. It takes a lot to put conferences together. The cheaper way to reach our members and non-members indeed is through this journal. Like the journal we're going to unveil now, we have 18 articles from some of our brightest minds in the legal profession, both the town and the gown, practicing lawyers and academicians have contributed to this. We have approached the firm of Templars, the topmost, I'm sorry, because if I say topmost now, there will be problem. Advertising. One of the topmost law firms in Nigeria. And we also have from Templars a man wearing two caps, a partner in Templars, and our very own Olumide Akpata, former president of the Nigerian Bar Association. Please, can we put our hands together for Olumide Akpata? In order not to take too much time, may I hand over the microphone to Olumide Akpata, Esquire, to do the unveiling. Presido.
Thank you, Mr. Chairman. Leonard Silk. I am most grateful for this honor, the opportunity, but let me preface the unveiling with a few comments about section on legal practice. I am delighted. I take personal pleasure and pride in the progress of the section on legal practice. And I must commend our chairman for holding the fort for the last 2 years, for doing it so well, so deftly. Leonard Silk, Mayana Essen, remember Owerri, she remembers very well. And when many of us were held responsible for certain things that happened, but all of that is behind. You know, SBL too went through his own travails. What cannot kill you will only make you stronger. And SLP is so much stronger. So much stronger. And I'm so proud of this section. Truth be told, I am so glad that all of us have worked so hard to make our sections as vibrant as they are, that very easily the national body can actually go to sleep and the 3 sections can keep the flag flying for the association. I'm extremely proud, glad to hear that AGM happened yesterday, glad to hear that we have incoming new leadership, and I can only wish the section more success as we proceed. And I commit to continuing my support for the section. So, with the kind permission, as Mr. Chairman has requested, I will unveil the journal of the section on legal practice. I must commend the editorial committee for putting this together. It is not easy. Oh, okay, I see. Led by Leonard Silk, Emmanuel Kala, SAN, to whom we are extremely grateful. And to the glory of God, benefit of mankind, and legal profession in Nigeria, I hereby dedicate or I unveil the Journal of the Section on Legal Practice, Volume 9, July 2023. Kudos to the section. Kudos to Isi Ukala, SAN, and his team for the effort, because I have been part of this at various levels and I know what it takes. For the effort, the law firm, my law firm will launch this for 2 million naira. But more importantly, Mr. Chairman, in keeping with the theme, the general theme of today's conference, or this conference, we must find a way to digitize. So I commit to working with the SLP to see how we are going to digitize this volume and make an online version of this volume. So I thank you, and I'm most grateful, and I will take a couple of copies and I would send our check. We are known to be good for it. We will send our check. I will pay quickly before the next thing adds another zero. But congratulations, SLP. Congratulations, SLP. And just permit me one other thing. My Lord had already commended the chairman of the last session. Let me lend my voice and thank my Lord for his very deft handling of the last session. I am so impressed that a judge from my state is on top of the issues as far as technology is concerned. And he displayed the fact that he's very at home with that, and I'm hoping that through him, the rest of the judiciary in Edo State and beyond will become versed, because this is a future that we cannot ignore. I thank you. Thank you, sir.
Just a word of thanks to Olumide Akpata. He demonstrates, or he has demonstrated what it means to have men of timber and caliber around you. He had less than 5 minutes notice that he will do this unveiling. And look at what he has done for us.
Thank you, sir.
Thank you so much. We are grateful.